Hello, everyone. Everybody get in here. Welcome to the live. Welcome to the live. Tell me where you're from. Give me a like. Let the algorithm know we're here. The algorithm know we're here. I've got a few things to go over. We have some developing news on the Diddy lawsuit front. You know, he had that partial win earlier this week when the judge did dismiss some of the claims in the Little Rod lawsuit against him, the music producer who's suing him. That guy is represented by attorney Tyrone Blackburn. One of the first lawsuits against Diddy. It was actually filed before he was arrested. But I think everyone remembers the Tony Buzbee press conference that happened and the flood of lawsuits we've seen since then. So much of the news has been about the Tony Buzbee lawsuits, and that's what this is about today. But I think it's important to remember that Buzbee isn't the only attorney who's suing Diddy, and there was some action earlier this week in another lawsuit. But what we're going to be talking about today is some news on the Tony Buzbee lawsuit front. So, Danny, thank you for saying hi. Hello, and Jamie, thanks for saying hi from La Quinta. I am excited to get into it here. We got to get back into the YouTube game, into the algorithm, and get everything juiced up for some more news. But these Diddy lawsuits, there's so many of them. And I think what really got everyone's attention on Tony Buzbee and his antics and some of the things he was doing in the Southern District of New York was how aggressive Jay-Z's lawyers were in exposing that. But then it seems like they've kind of passed the baton to Diddy's lawyers now. And there are some judges who seem to be taking a real interest in what is going on in the Buzbee lawsuits. So we can get into that today. So S-Dash, thank you for saying hi. Hey from downtown LA. Jackie, good afternoon to you. I am doing well here. Doing well on a Friday afternoon, just trying to get back into the YouTube algorithm, get everything juiced up, try to get back into the featured videos and everything. Trying to up the game here. So everybody, thank you for saying hi. Tracy, thank you for saying hey. Everybody give me a like. Let the algorithm know that we are here. We've got some news and some documents to get into, and I set this up before the news came down from the judge, where she actually set up a sanctions hearing, and it's an order to show cause, and she scheduled a hearing for Buzbee's co-counsel, probably privately, not technically in court. He's not a co-counsel with her, but she's the New York lawyer who's been filing all these cases for him in the Southern District of New York. The judge in one of the cases is all over her because she filed an affidavit, a sworn declaration from herself, saying that Buzbee had told her that he had never been denied admission in any district, when in fact he'd been denied admission in the Southern District of New York. And the filing she filed actually included proof of that, but then she filed something that she signed herself saying, oh, Buzbee's never been denied admission. So the judge was giving her an out. A couple weeks in a pretty recent order, said, basically just warned her about this, but then the attorney dug in her own filing and said, said, I wasn't doing anything wrong. So today the order to show cause came down, and there's going to be a hearing April 14th in New York. But that doesn't really affect Tony Buzbee so much. It's just the attorney in New York that he has filing this stuff for him. But what is going to affect him, and really it's affecting his clients, because I'm assuming these are real people that he's filing these lawsuits for. There's so many of them, but each of them lay out the kind of bare bones facts of what they allege happened. And yesterday there were two orders from the same judge. These cases in the Southern District of New York, there's at least 30 judges in the Southern District of New York at least, and the cases get randomly assigned. So the Diddy lawsuits are all assigned to a lot of different judges, but some of the judges just so happen to have multiple lawsuits. And there's a judge who has two lawsuits against Diddy, and both were filed anonymously under the John Doe pseudonyms, and she filed an orders in each case yesterday saying that she's not going to allow them to remain anonymous, that they have to identify themselves. And then today there was another judge in another lawsuit against Diddy. These are all Tony Buzbee lawsuits, who said that you could no longer remain anonymous, that gave them a deadline of April 4th to file something identifying themselves. So I went over the if you guys follow me on X, you'll see the news on there. I posted some of the documents, but we'll bring them up and check them out. So thanks for tuning in, guys. I gotta thank everybody for watching all the time and sticking with me here on YouTube. But if you guys follow me on X, I'm bringing up the this is the sanctions order from the judge against Tony Buzbee's co-counsel. So that's what I was talking about earlier, where she set an April 14th date. And this is the attorney who's been filing all the lawsuits against Diddy, and including the lawsuit against Jay-Z that's been dismissed. But she set a sanctions hearing for this attorney for filing false statements with the court, that she's referring specifically to the fact that the woman said Buzbee had never been denied admission in court, when actually he just recently had been. So that should be interesting to see what actually happens. I mean, I don't think she's going to be disbarred. Well, I in fact, I know she's not going to be disbarred, but it should be a tense hearing, to say the least. And it's not good. She's, young enough in her career that it's not exactly helpful for them to have something like that early on going forward. But let me see here. But this is the judge who rejected anonymity here. And this means this has happened in some other cases against Diddy too, where the lawyers just aren't, or the judges just aren't buying the idea that these cases need to proceed under the John Doe or Jane Doe name. That some different judges have done different analysis and said that they can remain anonymous, but we've seen several orders already saying that the filings can't be under John Doe. And that means that after these orders are issued, the lawyers go and file an amended complaint that, instead of John Doe or Jane Doe, actually names the people in the case. So that's what's going to happen in 3 cases now under these judges' orders. But this is the one order that was just recently issued. Of course, all of this is coming as Diddy has his trial coming up in May, and it still looks like that's actually going to happen in May. I think there was a lot of talk early on that it would get delayed, because I think a lot of people were expecting him to get co-defendants and superseding indictments, but that hasn't happened. There's been superseding indictments, but that have added a couple more victims, but we have not seen any co-defendants or additional charges. So right now, Diddy's trial is set to begin with jury selection. I think they were going to bring in the jurors a little bit early to fill out questionnaires, but they're hoping to get opening statements going by like May 12th or something. So once his criminal trial is complete, that's when we're really going to see, we could see some resolution of the lawsuits. I'm not really sure. A lot kind of hinges on what happens with the criminal case, obviously, but none of these have gotten to the discovery phase as they're as we're talking about this. But this is the order yesterday that a judge who has 2 cases against Diddy issued. It's an identical order, and she's rejecting the request to proceed anonymously. It's a 12-page order that she issued. Got it on the screen here. Need to zoom in for you guys. Thanks for tuning in, everybody. And this was issued in both both cases. She rejected anonymity in both cases. So that means, I think it's by April 10th, then 2 weeks, they've got to file the amended complaint that actually names them. And I think in the previous cases we've seen this order issued, nobody has dropped their case. I think everybody has identified themselves, but perhaps we could see that going forward. Maybe somebody will just want to drop their case instead of identifying themselves. But so far, we've seen everybody identify themselves and not just drop the case moving forward. But the judge goes over some of the case law here. And a lot of the times, it's pretty standard that the judges all have law clerks who work for them, usually pretty recent law grads. And it's usually pretty standard that the law students or the law grads are the ones who actually wrote the order. And that could be here. But sometimes, especially in a high profile case, you'll see a lot of input from the judge, or maybe they'll write some of it themselves. But it's pretty standard that you have law clerks that do a lot of this research and write it. But it says the court finds that the sealed plaintiff factor, she's citing a case here, weigh against allowing plaintiff to proceed anonymously. And she's going to address the factors in detail here. And the first factor is this litigation involves matters of a highly sensitive and personal nature, factor 1, and plaintiff has thus far kept her identity confidential, factor 7. And it says the first and seventh sealed plaintiff factors weigh in plaintiff's favor. So she's saying this is weighs in favor of anonymity, starting with the first factor, because neither party disputes that this litigation involves highly sensitive matters of a personal nature. So the first factor, does it involve highly personal matters of a sensitive nature? And the seventh factor is whether her identity has been kept confidential. It says there is no indication based on the current record that plaintiff has spoken publicly about her allegation. And this is, to be clear, this is a woman who accuses Diddy of attacking her in, I think it was 1991. So these cases really run the year span. It's one of the cases was 1991, one of them's 1998, and then the one that was just issued by another judge today is in a case in 2022, or an allegation from 2022. The case was filed this year, late last year. Judge says defendants further contend that plaintiff may have spoken privately to others about her allegations without receiving assurances of confidentiality. But this is pure speculation and would not necessarily tip the scales in defendant's favor, even if it were true. And I thought this was interesting. It says, the Buzbee declaration supporting defendant's motion states that plaintiff has not spoken publicly about the incidents that underlie the causes of action in her complaint. But as defendants acknowledged, the declaration is neither sworn nor made under the penalty of perjury. And I think that goes to the fact that Buzbee does not have standing. He's not admitted to the Southern District of New York, so he was probably worried about filing stuff like that. I'm not totally sure. There's so many questions about this. Procedurally what he's doing in this case. But it says the court also notes that the declaration is substantively identical to declarations filed on the same day in other Doe versus Combs cases in the district involving different plaintiffs and facts, which raises serious questions about the declaration's reliability. Yeah, that's why this kind of like warehouse assembly line litigation that they're doing, filing so many cases, when you would read the complaints and a lot of their filings, it's pretty minimum what's actually different in the filings. It's just the bare bones facts of the case. But when they're filing declarations that are the same in each case, like the judge says, it raises questions about the credibility. But she did say in any case the seventh factor still weighs in plaintiff's favor, absent any evidence that plaintiff's identity has not been kept confidential, because the seventh factor is apparently just strictly has her identity been kept confidential? And the answer to that is yes. But like I said, the judge ultimately ends up ordering her to identify herself. So she gets into some of the factors about why that is. So it says plaintiff's allegations regarding the risk of harm are speculative and insufficiently particularized. And that's factors 2, 3, and 4. It says the second, third, and fourth sealed plaintiff factors task the court with assessing the potential risks associated with identifying the anonymous party, including the potential for retaliatory physical or mental harm and the severity of such harms. On balance, these factors weigh against allowing plaintiff to proceed anonymously. She says, with regard to the second and third factors, which evaluate the risks that identification would present and the likelihood of those physical and mental harms, plaintiff asserts that Combs made, quote, threats of violence after the alleged assault. Combs told plaintiff that people can come up missing when she told him she wanted to report the assault. However, plaintiff provides no support for these allegations beyond this vague and unsworn Buzbee declaration, and she has not identified any present threat of physical harm. Generally, to justify the exceptional relief of proceeding anonymously, plaintiff must establish with sufficient specificity the incremental injury that would result from the disclosure of her identity. But plaintiff has not done so here. Likewise, with regard to the risk of mental harm, plaintiff contends that the playing out her traumatic experiences in a public forum could spark more trauma. But she provides no medical documentation or other evidence of the severity or likelihood of mental harm that would result from the disclosure of her identity. I think a lot of people would think it just seems obvious, but when you're dealing with a court and a judge, you can see why maybe she would want that. Plaintiff relies heavily on Combs's pending criminal charges to establish that Combs and the people within his organizations are dangerous. But plaintiff does not allege that she was the target of any of the conduct in the indictment, and there is no evidence that Combs has been in contact with plaintiff or made any threats in the last 3 decades. This is the woman who says she was attacked in 1991. And so the fourth factor here is whether the plaintiff is particularly vulnerable to the possible harms of disclosure, and the key being particularly vulnerable here. And it says plaintiff is currently an adult, was not a minor at the time of the alleged incident, and has not identified any reason for the court to treat her as more vulnerable from the great run of adult plaintiffs who bring allegations of sexual assault in their own names. Yeah, and that's the thing. They're just looking for you can't just be like everybody else. They're looking for what's particularly vulnerable about you. I mean, I think everybody could argue they're vulnerable, but I think the key there is particularly vulnerable. So again, this is the ruling saying that the woman suing Diddy has to identify herself. And this judge issued the same ruling in 2 cases yesterday. And then another judge in another case issued a similar ruling saying that a man suing Diddy for allegedly assaulting him in 2022 has to identify himself. So, and you can find the links to these on my X page. I've got that link down there. If you guys don't follow me on there, you should. But give me a subscribe, give me a like. Let me know how everything's going. But it says plaintiff relies heavily on, it says plaintiff relies heavily on Combs's pending criminal charges to establish that he and the people within his group are dangerous. But again, it says that she doesn't say that she's been the target of any of that. And so then they get into the 5th, 8th, and 9th factors. It says the public interest factors cut both ways. It says turning first to the 5th factor, which looks into whether the suit challenges the actions of the government or that of private parties. Here, plaintiffs challenge the actions of private parties. Thus, there is a significant interest in open judicial proceedings weighing against the use of pseudonym. Next, the eighth factor weighs whether the public's interest in the litigation is furthered by revelation of the plaintiff's identity. And it says this factor weighs in both directions. As courts have routinely observed, lawsuits are public events, and the public has a legitimate interest in knowing the facts involved in them. And she's citing a previous order where they rejected anonymity in the Combs case, and the order apparently cites a lawsuit against Tupac Shakur from 1996, or Doe versus Shakur. Make sure that's actually Tupac. There is also a public interest in the accused being able to publicly confront an accuser, a right that would be undermined by plaintiff's anonymity. The public interest in knowing the identity of the parties is magnified where a plaintiff has made the allegations against a public figure. But courts have also noted that the public generally has a strong interest in protecting the identities of sexual assault victims so that other victims will not be deterred from reporting such crimes. Lastly, the ninth factor suggests that I'll turn the page for you guys here. So yeah, I think this is the one that gives them until April 10th to file an amended complaint identifying them. Says, as defendants correctly observed, there are other mechanisms to protect any confidential information that may be disclosed during discovery or as part of the case. It says blanket anonymity would significantly prejudice defendants, and that's factor 6. In such a situation, when one party is anonymous while others are not, there is an asymmetry in fact gathering. This asymmetry is more profound in cases involving substantial publicity because information about only one side may come to light as a result. And that's been the argument we've seen in the other cases, is that they want the public should know who it is because they might have information about what happened. And of course, we're seeing that happen with Diddy with all the lawsuits coming against him. But I think the defense attorneys for him are saying that perhaps people in the public would know something about the accuser's credibility, but they're not coming forward because they have no idea who the accusers are. So this is the judge weighing that right here. She quotes case law, confidentially disclosing the plaintiff's name to the defendant's counsel, as plaintiff's counsel suggests, would not eliminate the potential prejudice. The potential prejudice to defendants is particularly stark here because plaintiff is bringing a lawsuit about an incident that allegedly occurred approximately 20 years ago, which may be difficult to defend even with information about plaintiff's identity. They're citing another case here. In this case, they were saying it's like 30 years ago, 1991. So it says, accordingly, the court finds that the sixth factor weighs strongly in favor of disclosure. And then this is coming to the conclusion here, the balance of factors weighs in favor of disclosure. On one hand, the case involves highly sensitive personal allegations. Plaintiff has thus far kept her identity confidential, and the public has a particularized interest in encouraging the victims of sexual assault to confront their accusers, who are often powerful figures. On the other hand, plaintiff brings factually grounded claims on a topic of significant public interest against a well-known figure, and the public also has a strong interest in maintaining the customary and constitutionally embedded presumption of openness in judicial proceedings. And significantly, plaintiff has not provided any particularized evidence or even non-speculative allegations to establish that the disclosure of her identity would result in concrete physical or mental harm to herself or third parties. Such evidence plays a vital role in the balancing of competing interests in these cases, and its absence is particularly salient here given the risk of severe prejudice to defendants from continued anonymity, hampering their ability to confront their accuser, guard against reputational harm, and defend an action based on events from more than 3 decades ago. Yeah, there's 30 years. In sum, plaintiff has not provided the court with enough information to tip the scales in her favor. Conclusion. For the foregoing reasons, the court denies plaintiff's motion to proceed anonymously. Plaintiff shall file a complaint in her own name no later than April 10th, 2025. The clerk of court is respectfully directed to terminate the motion at docket 15. That's the motion that she just decided, the motion about whether the motion requesting to proceed anonymously. It has been rejected and the motion is terminated because it is resolved. And that was yesterday's order. And she issued a similar order, except addressing Jane Doe as John Doe in another case against Diddy that she's also been assigned the judge. And that's a case where a man alleges he was attacked by him in 1998. And then today we had the other case filed. So, yes, Queen. I did cover the Judge Viscal response to Curris for the playback crew. They could find that early in the setting. But yeah, we did go over that, and yeah, she's in trouble. I mean, I think Buzbee's kind of plan to kind of set her up to take the fall for him is kind of working. Like, she's not really in trouble. He's not in trouble in that particular situation, but he could be in trouble overall in the New York State Bar, and just all his lawsuits are getting screwed up in the Southern District of New York because he's withdrawing from all these cases, and it's unclear whether she's going to be capable of like going to court and litigating all those on her own. But she's ordered to be in court on April 14th, and she has to, it's an order to show cause. She has to show the judge, like, basically why she shouldn't be sanctioned for saying something that isn't true in a sworn filing. And it's, what's notable is that the judge gave her kind of an easy out on this gave her an easy out on this back in the order, and just said that, you know, don't do this again, or said that she would take this seriously if it happened again, that kind of thing. And she ended up filing a really kind of snotty response to it, like basically telling the judge that she was wrong. And so this is the judge's order day. I've got this on Twitter if you guys can see it. Damn. Can't really make it big for you. But yeah, April 14th, she's got to file something, and then she's got to go to a hearing and show cause for why she shouldn't be sanctioned for this. So because she wrote in a filing that Buzbee had never been denied admission before, even though he'd just recently been denied admission to the Southern District of New York. And then when the judge gave her kind of an easy out in that filing and warned her and just said, you know, you opened yourself up for sanctions, moving forward, you know, be careful. I'm not going to take things lightly, or whatever it was. Her response to that was to file like a really snotty response telling the judge that she got it wrong, and not even acknowledging this stuff about how she falsely said that Buzbee wasn't facing sanctions. Although her filing said that Buzbee had informed her that he'd never been denied admission. Excuse me, not that he'd never faced sanctions, but that he'd never been denied admission. So maybe she'll just point to that. But she definitely got herself in trouble through her response to the judge. So yeah, there's been kind of a floodgate of news. There's just so many cases, and the judges all kind of work at their own paces and address things in their own way. So every day it seems like there's a new filing in one of the like 30 lawsuits that against Diddy in the Southern District of New York. But Buzbee is not stopping the lawsuits at all. Like, he still is definitely representing all these clients against Diddy, and instead he's just switching the courts that he's filing them in. He filed one recently in LA. I haven't actually seen, I've seen the reports of it, but I've seen, let's see if we can get Buzbee here. He posted something on his Instagram about how he doesn't like how he doesn't like fake news, but he doesn't like the term fake news, or he's never liked to talk about fake news, but he needs to acknowledge, all these reports that he's somehow withdrawn from the Diddy lawsuits. But he kind of dances around the truth, because it's not people. I think in my reports earlier are about this confusion about whether he's admitted to the Southern District of New York and then he withdrew from all those cases. I think I talk about how we don't know what his deal is with this judge or this New York attorney who's filing cases for him. They might have all these signed contracts saying that, behind the scenes, we're going to split the work and we're co-counsel on this, and those contracts would still be in effect. But in the Southern District of New York, just technically, he was never co-counsel on any of those cases. And then his name was on all these cases, and he started to seek admission in some of the cases, and now he's withdrawn from that, and he's actually filed stuff telling the judges that he's not going to be seeking admission or seeking to do anything about those cases, but that she's going to be continuing on it. And I'm assuming that means that behind the scenes, his law firm is still involved in all those cases, but it puts him in hot water, because he can't really do much. He really can't, especially with some of these judges that he's pissed off. He can't be filing anything or anything like that. So the New York attorney that he has doing this work for him is obviously now in the hot seat, but it's a question of what is her personal agreement with Tony Buzbee, and what is she going to decide to do with him. But this is Buzbee talking about how he's not giving up on suing Diddy at all. But he says, I've always thought that those who threw around the mantra fake news were a bit overdramatic and hysterical at times, but I've grown to realize that maybe I was a bit too hasty in that respect. I've come to learn that some organizations report and post news items that they know are untrue or know are misleading to get views and clicks. One such item was that I've bowed out of all the Diddy litigation. Let's be clear. You heard it here first. I have not withdrawn from all of the Diddy cases, period. Indeed, that couldn't be further from the truth. Today, we filed suit for a professional photographer who alleges coercion and sexual assault against Sean P. Diddy Combs. Plaintiff is a well-regarded professional photographer engaged in the production of television commercials. The lawsuit asserts that in late 2022 or early 2023, plaintiff John Doe met defendant Sean Combs on the set of a high-profile commercial that plaintiff was hired to work on. According to the filed complaint, plaintiff asserts that Combs encouraged him to join him in his trailer for an opportunity to advance his career. Plaintiff did so. Plaintiff alleges that the sexual assault occurred there. The specifics and details of the claims are set forth in the case on file in New York State Court. The facts alleged speak for themselves. And the key is their New York State Court. Like I said earlier, he's moved to New York State Court or LA State Court. He also recently, in the last couple of days, filed a lawsuit in LA Superior Court, I've heard, which is California State Court. So it's not, like I said, we don't know what his deal is in the federal cases in New York, other than he just technically is not a lawyer on the record in those cases, but behind the scenes he could still be involved. But he did formally tell all the judges in those cases that he's not going to be seeking admission or working on them. And then, like I said, he's focusing now on state court. So it's a little complicated, but it's just kind of an example of maybe the problems of like wholesale this like wholesale approach to litigation. You're just filing so many cases at once. And it's always been a question of why he didn't just seek admission to the Southern District of New York originally, because he is licensed to practice in Texas. And I don't think that's ever going to change. The idea that Buzbee is going to ever get disbarred in Texas, no way. I think it'd be tough to get him disbarred in New York. It just depends on what happens. We'll see what happens in all these lawsuits with him, or if he actually gets a successful judgment against him for malicious prosecution or something that could affect him. But the strange thing is, given his status as a licensed lawyer in Texas, he has a license in New York State Court, and then he's also admitted in the Eastern District of New York, which is federal court in Brooklyn, and that basically has like almost reciprocal automatic admission to the Southern District of New York, because they're basically sister courts. I mean, Southern District of New York thinks they're better than Eastern District of New York, but they're right next to each other. So if you're admitted in the Eastern District of New York, it's pretty much a given that you can get admitted to Southern District of New York. The problem is Buzbee just didn't even try. He had this New York attorney file all these cases for him, and we all saw all the litigation and Alex Spiro going after him over the Jay-Z claims, and he never sought admission until like after they'd all been filed. And then when he did, he got rejected, and the Southern District of New York judge told him that it was because he'd filed all this stuff before he'd sought admission. So it was always a question of why did he do that? Why didn't he just seek admission early on? If it's pretty much a given, he would have gotten it. And I think Jay-Z's lawyers kind of have some points where they say that he did that because he wanted to avoid any kind of sanctions or problems in New York in those courts for filing bullshit lawsuits, filing stuff without doing due diligence on the clients, that kind of thing. I mean, I don't know, because like I said, it makes you wonder why you would do that, because it's so automatic, and not doing so ended up screwing him over. And you just got to wonder about all these clients and what they're going to do with their lawsuits. And the 3 people who were just recently told that they have to identify themselves, there's just a lot of problems here. But anyway, yeah, I see your point, Queen. You say, I think he thought the defendants would just settle the cases. I don't think he ever planned on going to trial. Yeah, all the litigation has been such a mess. But yeah, I think you summed it up here when you say this is a mess for sure. So yeah, definitely. It's as the lawsuits turn, for sure. But thank you guys so much for tuning in. I am still getting back into things here on YouTube, juicing up the algorithm and everything. But give me a like if you can. Let me know that you're here. You can find more news on legalaffairsandtrials.com. And I will try to be back later. Let's see, next week we've got Soulja Boy back in court for his civil trial in Santa Monica. I've been covering that. He's accused of like sexual assault and kidnapping by a woman he'd hired as his personal assistant, and had lived with him for a couple of years. And it's a messy case. She has photos of that are being used as evidence, and a lot of text messages, and it's just it's a messy trial. But I think he might be testifying next week. I think it starts again on Tuesday, so I'm gonna go to that. But yeah, Lakia, thank you so much for watching and saying hi, for sure. And April 7th, Jay-Z's lawyers are back in court with Tony Buzbee's lawyers. But if you guys go to legalaffairsandtrials.com, my website, you can find my latest coverage on that. And thank you so much. I hope you guys all have a great weekend. I'll see you guys later. Thank you.